Perhaps let's start. I see that people are still joining in, but I think we're going to go through the introductions and all of the things that we need to go through. And then, by the time the presentation starts, hopefully everyone else who's registered joins. So hi, everyone. So my name is Masha Kardashevskaya. I am a research associate at Resolve Manitoba. Welcome to our webinar, Family Law, Family Violence, and Restorative Justice. Next. So before we start, I would like to acknowledge the lands where the University of Manitoba and the Resolve office are located. We're located on original lands of Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. And if you're joining from other lands, I invite you to acknowledge the land and territory you're joining from. Next. So today's webinar is part of a project titled Supporting the Health of Survivors of Family Violence in Family Law Proceedings, funded by the Public Health Agency of Canada. The purpose of the study is to initiate, host, and support a community of practice comprised of experts and practitioners in the family violence and family law sectors to enhance the capacity of practitioners to address family violence safely and effectively. Through this work, we hope to enhance support to survivors of violence through the family law system by increasing opportunities for family law practitioners to have training, guidance, and resources to support trauma-informed practice and to improve coordination of services that will enhance the safety and well-being of all parties. The project has been running since November 2020 and will run till November 2023. And the project is hosted by the National Alliance of Gender-Based Violence Research Centers in Canada, with Western University as the lead. And we bring together, as I mentioned, a community of practice that consists of experts in family law, IPV serving organizations, IPV survivors, and others. Next. I would like to acknowledge our speakers today, Tod Augusta Scott and Lisa Teryl. I also would like to acknowledge our funder, Public Health Agency of Canada, and Resolve staff members, Dr. Kendra Nixon, Resolve Director, Ashley Holler, a research technician, Patricia Karaksani, a digital communication specialist, and also the University of Manitoba audiovisual team that is helping us to host this webinar today. Next. So just a few webinar guidelines. The webinar will be recorded. Participants will remain muted and have their video turned off during the entire webinar. And then during Q&A session, participants may ask questions by clicking the Q&A button, which will be on the bottom of the screen. Next. Our schedule for today is welcome, land acknowledgement, and introductions. Then we will have a presentation with Tod Augusta Scott and Lisa Teryl. And then we will have a Q&A and closing remarks. Paul, next, please. So we have a poll question, a small poll for you. And the question that we ask is in terms of the sector that you represent, so that we can see who's joining us today. So I will give you a few seconds to select your sector or field of work. So that should be enough time for everyone to select their options. Thank you for taking the time to respond. I would like to welcome everyone. Thank you for joining us today. And before we move on to introductions, I wanted to give you a gentle reminder about the disturbing content. The webinar contains materials of a highly sensitive nature that may be disturbing for some individuals. So I encourage you to access resources available at the link that we provide in the chat. Thank you, Ashley. Next. So I would like to give a warm welcome to our speakers today. Tod Augusta Scott is a renowned advocate in family violence and trauma. He has international acclaim in the fields of family violence, restorative approaches, trauma, and narrative therapy. Widely published and the sought-after presenter, Scott's groundbreaking work has been featured in numerous publications and even captured in the documentary A Better Man. Additionally, he serves on the Advisory Council for the Status of Women in Canada and has received prestigious accolades such as the Award of Excellence from the Deputy Minister of National Defence for his efforts in addressing sexual misconduct in the Canadian Armed Forces and the Distinguished Service Award from the Canadian Association of Social Workers. Lisa Teryl is a seasoned senior lawyer. She brings a wealth of legal expertise, having served as a senior legal counsel, utilizing a restorative approach at the Nova Scotia Human Rights Commission for 6 years. Recognizing her remarkable contributions, she was honored at the Schulich School of Law, Dalhousie University's Extraordinary Alumni Lunch. Since then, Teryl has been actively involved in developing a framework for creating separation agreements that prioritize restorative principles, particularly in cases involving family violence. Tod and Lisa have come together to introduce an innovative approach to family law. Their brainchild, Divorce Legal Communication Services, aims to put an end to abuse, foster collaboration, and streamline the divorce process through adopting a restorative approach. Now I would like to give the floor to our speakers today.
Okay. Thank you, Masha. We're glad to be here. Greetings from Canada's East Coast. And my name is Tod again. I'm just going to try and that. And it's great to see, social workers and lawyers and, just all the different sectors together trying to address this issue in terms of domestic violence and partner violence and family violence and the law courts system. So over the next hour, Lisa's going to actually present first from her work in the law. And then I'm going to present on my work in the field as a social worker in working with both parties and a process that we have in place for that. And we'll show how we've been integrating. So Lisa and I work both together at the Human Rights Commission as well. That's part of where our work started to kind of resonate with each other, and then moved it into the work that I was doing in the community, moving that, and the work that we were doing at the Human Rights Commission, moving that into a family law context. So I'll let Lisa introduce herself, and she'll be taking the first half, and then I'll take the second half, and then we'll open it up for questions. Does that sound okay, Lisa?
That's great. Thanks, Tod.
Okay.
Okay, so as Tod said, I'm Lisa, and I think we've already had an introduction there for both of us. I think how I would like to, I've been practicing for 25 years. I guess that wasn't in the introduction. It's kind of a relevant data point, actually. And I say that because I think some of how I'll start this talk is to sort of give you a sense of like what I felt I didn't have and what I felt we had to get by the time, like in terms of how I've arrived and where I've arrived in my family law practice. And so, as the introduction said, I for 15 years I practiced in private practice, and then I went to the Human Rights Commission of Nova Scotia, and I worked there for 6 years. And prior to that, I had no theoretical or philosophical understanding of justice. And I'm actually a little bit embarrassed to say that I didn't know really what meaningful justice was until I studied restorative justice. And I had the opportunity to work with a law professor named Jennifer Llewellyn there, and very rigorous intellectual in-depth understanding of restorative justice and the principles. So as part of that process, we did a lot of changes, and I did a lot of restorative justice work in terms of resolving complaints at the Human Rights Commission tribunal level. That was where I came in as senior counsel. So from that experience, I actually began to formulate a critique of the traditional justice system. It was interesting because I emotionally, at some level, I knew I wasn't satisfied with the justice system that I had to work in. I saw that there were, for example, in my world, there were a lot of unhappy lawyers. There was a lot of adversarial processes. It was just so conflict-ridden, even between the lawyers, let alone the parties. So I just didn't really feel like I had the tools, and I really didn't like to practice family law, the traditional sort of lawyer representing each, a lawyer represents each client, and we write letters back and forth, trying to settle it. And then, then you go to court, and the affidavits are like scathing. In my early years, I cringe at the affidavits that I wrote because I wasn't aware of the impact on the family. Like, these people have to, if they have children, they have to actually like co-parent together. And so there wasn't an awareness, and that I feel like that kind of gets bleached out of us, if you will, as lawyers. really wasn't an awareness of like the harms that we incidentally, like we don't realize it as lawyers, but the harms that we create families by the structures that we were using, the family law structures. And by structures, I mean an adversarial legal system, actually. And so that's like the lawyers take positions and their clients have positions, and we think our position will win and yours won't. And when I said this to my non-lawyer friends, like that we, have an adversarial legal system, they said, well, you don't want to throw stones at the system. I said, no, it really is adversarial. Like, no lawyers will disagree with you. That's what we call it. It's the thrust and cut of litigation. You cross-examine, you direct examine. That's the nature of the system we have. There are other legal systems, like in France, it's more of an inquisitorial system where the adjudicator or the judge actually takes on part of this investigation process. So it's more collaborative. So in terms of when I arrived at the Human Rights Commission, I was trained as a litigator. I did a variety of law, but I did a lot of family law as well. And I also did civil litigation. So when I went to the commission, I got a unique opportunity because of the restorative process to understand what a more collaborative type of law would look like. And I must say, I think a lot of lawyers would still say this. I didn't really appreciate collaborative law at all until I actually had this experience. And so what I did in that role, so I was, in a traditional sense, I was the prosecutor of human rights complaints under the Human Rights Act, if you will. They didn't call it that under the Act, but that was sort of the traditional role. And so what I did was, as a facilitator, as a restorative facilitator, what I said was, okay, I'm going to actually make this more of a collaborative process, and that's one of the principles of restorative justice. And I'm going to, so to be more restorative, I'm going to search for fair and reasonable outcomes. So, and that actually is the role. I have the public interest role. And so that put me automatically in a neutral position, actually, similar to the way Crown attorneys are supposed to be, but it's so adversarial, you don't actually get that sometimes. But it put me in a neutral structure. So I was able to say to the complainants, this is what I think is fair and reasonable. This is what I think an adjudicator would say. I was able to say that to the respondents, like, what is the nature of the harm here? What's a fair and reasonable outcome? And so we developed a whole structure and systems in there. So from that, I left after 6 years, and I had, again, the very unique opportunity at 20 years of experience at the bar to come back and say, okay, if I could do all of this over again and run my own practice and do it in a way that tried to minimize the harms for all of the parties involved in a family matter, if I could do it collaboratively, if I could do it transparently, and I could do it in ways that minimize the financial harm that also happens to families when they get caught up in the family law system. We were just talking before we came on to date, and someone yesterday told me that his friend, I'm changing the details slightly, but his friend had just recently taken out a mortgage for $52,000 or whatever for his family for his family lawyer's fees. And so that type of harm is devastating to families as well. So when I came into my private practice again, I also felt like emotionally I wasn't able to do the adversarial system the way I used to do it before I learned about more of a collaborative type restorative practice, because I was now aware and sensitive to the harms that was created by the adversarial process. So as I moved away from the traditional tools that I used, I didn't even recognize it until after I left that experience at the commission. I actually had changed my moral structure as well. So I reinvented my entire practice, and so in the early years, I did two things, actually. I developed a mediation program for low conflict situations, which wouldn't involve any domestic violence. They're fine. They can talk, but they just do disagree on spousal support or pension division or things like that. And so that mediation program turned out to be very successful. And it took a while, though. I didn't really appreciate actually all the tools that I had inherited as a mediator, and so I modified some of those, and I created. There's no confidentiality for me as a mediator in those programs, and there was, like, the current kind of culture here in Nova Scotia was that you always, everything was confidential, but I just didn't find that helpful. I found it raised the suspicions and things like that. Some of the other work, though, that I did at the same time was with high violence, highly abusive relationships while I was sorting through the mediation program. And so it was immediately clear, and thank goodness from Tod and I have worked together at the Restorative Justice, in Restorative Justice at the Human Rights Commission. And so, you know, I was like calling Tod. Tod and I are actually siblings. So I'm calling him on the phone and saying, Tod, like, why are the respondents like minimizing, denying, and blaming? Like, I've got them all, I'm talking to them, and then they're saying they don't feel heard, like when we're doing these restorative processes. And he says, well, Lisa, did you do this, and he lists these 10 things. Like, did you ask the respondents this? Did you do to deal with this minimizing, denying, and blame, which is so common when the person who's done the harm does the harm. They need to be handled in a very particular way. So from that, so I did have a background in terms of understanding immediately that, like, if they're high conflict, that high conflict in my world, in the legal world, but in my world in particular, is like a broad umbrella. And within that high conflict, there can be domestic violence, or it could be just they just can't speak to each other, and there probably is abuse, right? And it might be going both ways. It's a broad spectrum. The ones, of course, that I had to be like the most challenging ones, of course, are the ones where you have extreme power imbalances. And so the model that I eventually like worked through, but initially I always kept these parties apart because I had this previous experience with Tod, but I kept these parties apart, was that I would work with them separately. I'd also worked with Tod, and Tod is the therapeutic lead at the local domestic violence shelter. So I was allowed to come in and train for 2 years with all of these therapists in sort of a therapeutic setting to understand how we do certain techniques around de-escalating. Because what I was finding, and now I don't have to do it very much, but at the time I just needed to learn those skill sets. But it was really challenging to de-escalate someone in my office. They couldn't hear the law because they were so mad or so afraid, or so they're just like all of these emotions, and I wasn't actually able to move the legal part forward. So so Tod and I, so then we, so I eventually developed this, this, what we have now is the 5-week facilitation. It's the divorce legal communication program. And that is a refinement that actually does involve participation with the family court here in Halifax, and really across the province. So I'll just go in briefly into, I'll just do a time check here. Yeah, I'm okay. So what that
Do you want the PowerPoint slide?
yeah,
or-
sure. Yeah. Okay. Let's have the first PowerPoint slide that says objectives, if you would.
Okay. Can you see that okay?
Yes, you might want to make it a full screen there as well.
Yeah. Mhm.
Okay. Great.
Okay.
So yeah, so so even just the concept of like restorative approaches or restorative justice, that is something that, again, sometimes restorative justice done poorly is just very harmful. And when it's done well, it's an amazing thing. So it really needs restorative approaches, and restorative justice itself is something that it just requires a lot of training and skill to understand what justice is and how you take care of the safety pieces. And so that just throw that out there. So these programs were first and foremost in any sort of a justice situation, but a restorative approach is that we have to create safety first. We have to shut down the harms. When those harms are shut down, then you can move on to, okay, how are we going to build the legal separation agreement, or how are we going to do these things? And so sometimes when people are calling me and they're saying that, you know, he's going to take the kids and, you know, immediately go, my reaction as a facilitator at that point is, okay, we got to stabilize the situation. You both need to immediately go out and get lawyers. Now, I'll just go through these various objectives, and then I'll explain specifically what the 5-session program is, sort of like a 4-week session with an added session on the end. I'll explain that, but I'll just go through this. So I've mentioned earlier that we're sort of building nonetheless, we're building collaborative separation agreements. So the idea as well, from my perspective, was to expedite. How do we expedite this? How do we not rush it, but although it is a short timeline, how do we do it in a way that allows the parties to manage their legal budget in a way that doesn't, you know, they know what it is. And so we establish flat fees for the process, right? So they know what they're getting. And with the 5-session program for the divorce legal communication service, that actually I guess maybe I better jump in and just explain the program first. So it's a 5-session program. The first 4 weeks are, I meet with each of the parties for 2 hours separately in week 1. And in that week, and there's, it's week 2, the same thing. I meet with both parties for up to 2 hours each separately. Week 3, up to 2 hours each separately. In between week 3 and week 4, typically, their lawyers are going to become involved, and they're going to go out and see their independent legal advice lawyer. So they can't do this program I don't do any of my mediation programs either this way. You always have to have independent legal advice for low or medium or high conflict situations. So they go out for independent legal advice at the latest between week 3 and week 4, although they actually do need to contact legal and legal advisors early to review this contract, because week 4, then they both bring their notes that they've taken from their lawyers on these agreements. The agreement that I've drafted the separation agreement. And then for those of you who aren't lawyers, that separation agreement is the contract that binds the party. And if you're married, it becomes the terms, uncontested terms for your divorce once you sign that contract. And if you're common law, the separation, it just binds the parties on a go forward. And it takes care of the property, property, pensions, debts, assets, parenting times, and child support and spousal support. So in week 4, the parties come back from their legal counsel and they take the notes, or their lawyers send them emails just highlighting the tweaks or the changes that they would like to make to my suggestions in week 4. If we can't get it resolved, and so for the high conflict or domestic violence cases, it was interesting, the stats. So there's about a 50% success rate I've had as a mediator. So I've been doing these mediation programs for the low conflict and these facilitated divorce legal communication services for the high conflict for the last 8 years. And so between for the low conflict last year, I did about 30, and about 28 of them all settled. The ones that didn't settle were the high conflict ones that said that they were really getting along when they weren't, and then they should have been in the high. And so we developed this high conflict program from that. So the parties actually give me their notes from their lawyers. I tweak that. If they can't get along, there's only like a 50% chance I'm going to help these people be able to actually sign those separation agreements. And so if they can't get that signed, then they go to the family court. And so at the very beginning of this process, in week 1, the first documents that we prepare, and everybody has signed a contract. So if it's a woman and a man, he signed it, she signed it, and I've signed it, that we're going to end up, if we can't get everything resolved, the one point that we can't get resolved, we'll go to what we call a binding settlement judge. And so we collaboratively do the documents, all 3 of us, and create the documents. I select, doesn't matter which one, I select one to be the applicant, one to be the respondent, and separately in separate calls, but I fill out all of these documents and they sign all of these documents. And all of these documents go to the court before I start any other work. They've signed a legal contract that acknowledges that they understand this process. So when that collaborative, but traditionally adversarial product, but anyway, when that collaborative product goes to the courthouse, that triggers a court application. And so neither party at that point can back out of it. Okay. And so it's designed that way because we want the court in Nova Scotia in particular, the court here will pretty much almost everybody goes to a settlement conference. There's like rare exceptions, but basically everybody really needs to go in front of a settlement judge who's not the trial judge to see if they can resolve it, because they have a 90% success rate also in solving these cases. But they have this additional program where if the parties agree to it, you can have a binding settlement judge. And that judge will actually, if that judge can't resolve it after a half day or a full day of talking with both of the parties, understanding what's going on, then they will order this. They will order what the judge thinks is fair, reasonable, and it's not appealable. So this is why everyone needs independent legal advice. The parties need independent legal advice at the very beginning of that process, so they understand that you're both signing off on binding settlement judge process, that will happen. In Halifax area, that takes about 4 months to get in front of that binding settlement judge. Now, the price point for this product, for example, is in Nova Scotia, we don't have a lot of money. So everything is like way less expensive than in Ontario. I don't know what it's like in Manitoba. You might be more in our field, but the price point that I was able to figure that like will work is $4,900 for each party. And so that the worst case of domestic violence, abuse, everything, the legal fees, if you end up taking that to trial, are horrendous. So in Nova Scotia, it's about $20,000 per day per person for legal fees. So if you have a 1-day trial, each party's going to, if with their lawyer, they're going to pay their lawyer $20,000 per day. So if they have a 2-day, they're going to pay $40,000. So there's a famous Armorian case here in Nova Scotia where he was, by all descriptions of the Court of Appeal case, was economically and probably otherwise, but I didn't hear that part, but just economically abusive toward her, tried to bankrupt her, and he had to pay her legal fees, which were over $1 million for this. I think it was a 6-year odyssey or something. So it's a very significant issue, and that's why we put the flat fee on it. So the charm of the program, I guess, is that at some level, everybody can understand what's fair and reasonable, but the emotional harm that's happened between the parties, it just won't allow people to emotionally settle at my stage, and they actually need a judge to either get them to settle it at what's fair and reasonable, or the judge actually orders it. So that's the basic outline of the arrangement that we have. The family court's agreeable to do that. The parties don't necessarily need lawyers to show up at the settlement conference. I recommend that they do each have a lawyer to show up at the settlement conference. We've prepared all the documents at the very beginning of the process, as I said. I help as the facilitator, neutral facilitator. My role is neutral between the parties. I help write sort of like a 3-page memo that sort of just says, okay, this is her take on it, and this is his take on it, right? I don't take a position between the two of them. I'm just trying to make them make sense to the judge. These are the relevant facts that this is what she's saying, and this is what he's saying. So that, and then with the parties, ideally, they each have lawyers to go into that settlement conference, and then that's the end of it. There's no direct examination. It's much more of this inquisitorial method that I talked about earlier, which is the adjudicator, or judge in this case, is going to ask the questions. These are very sophisticated judges. They very much do know the questions that they need to ask to get a settlement conference on most things in a half day or a full day. So that is the general gist of the program. I wonder if there's I guess, yeah, we can just see if we covered everything there for the PowerPoint. I find just like if there are any like mediator types, I call it facilitation in this context for a couple of reasons. I find that mediation is it doesn't resonate well with people in high conflict. They're like, there's no way you're going to mediate this for sure. But it's also like, it's really more of you never bring the parties together. So it's not, it is facilitation, and I'm facilitating both of the parties to focus on and be able to focus on what's fair and reasonable. So the way Tod and I have worked at developing the program is that in the high conflict ones, I now have the ability, and we've like integrated this onto our websites, is I now have the ability to say, okay, if you two in the future, you have children and you need to communicate with each other better, we can actually have you you have to pay for these counselors, but you will benefit from this 5-week process if you have one of these counselors who are specifically trained in domestic violence, or I don't use that word for the parties, it's more neutral, but just high conflict situations. And because they need help on how to how to communicate in safe ways, how to communicate in ways that are respectful. So in that process, I can develop a rapport with the parties and assess what the needs are, and then assign each of them what I call communication counselors, right? What these are communication counselors, though, that have a very specific background, and that's Tod's training. The counselors at his firm are all specifically trained in domestic violence and seasoned senior counselors. It really does require, I would say, the senior set in my experience. They need to have like master's degrees, and they need to know how to do these things. And so, I mean, I have like 3 more minutes. I guess I maybe could give you another. Tod, did you want to ask me any questions that you might have thought I had forgotten?
Yeah, sure. Well, I mean, things that, so, I mean, I'm going to talk about the interface between the social workers and the lawyers. I mean, part of just to kind of footnote it here, part of what the social workers are also doing, I mean, just to underscore, Lisa, what I was hearing you say earlier, just that often Lisa would talk about just how much trauma she was dealing with in the
yeah.
conversations, and how the trauma from either or both parties was actually preventing them from actually creating a fair and reasonable settlement. And so part of what Lisa might do is recruit us into that process. So there's always two restorative facilitators or therapists working with both parties. So both parties are
Separately.
separately. That's right. So we're working with both parties, one to stop the abuse, of course, and then also to look at repairing harm, which is what I'll be talking about. But within that 5-week process, I mean, our work with the two parties can extend well beyond, of course, 5 weeks.
Yes.
But in terms of initially trying to get that engagement so that a settlement can be created. So again, so we can thwart, among other things, the economic abuse that can happen in through family court. So that we would be able to work with issues of trauma and gender, and how those end up interfering with the ability to come up with a settlement agreement. So that's really how the two processes are working together. So we'd be working to address safety and so forth, which I'll speak more of. They also I want to underscore, because I think it's important in terms of just having that financial framework that really, I mean, part of, I think, people's experience in the traditional system is the costs always seem out of control, and it just feels like a death through 1,000 cuts. And this really and often that's letters that are being sent back and forth and so forth. What this process really puts on the table is that if you want to continue this conflict, this isn't this is going to cost a lot, that they're contracting about how much money they're actually going to spend up front. Because seldom will people come to the table saying, I want to spend $40,000 on the first day of court. $40,000, that's just not, if they're given kind of informed consent around all that kind of stuff, that that they can make whatever choices they can probably afford to, but at least with their eyes open. Did you want to say anything more just about that, Lisa, before I move?
I think maybe just a couple points to add to that in terms of like what I find unique about the need for therapists is like in the 5-week program or the 5-session program, they really do need like particularly the person who's victimized and the power imbalances against them. That person really does need to have their lawyer, but like I encourage both parties, but have their lawyer with them throughout. So I often like always on these high conflict ones, I always talk for 5 or 10 minutes with each counsel before I get into the process, because I need them to set their expectations on what their role is. Like they're never to contact each other as counsel. They're just to go through their clients, and then their clients deal with me and we deal with it that way. But they do need the support of their lawyer. But at the same time, they really would benefit from, if they have existing therapists, those therapists being on call for that 5-week, or like it takes 4 months to get the 5th session. But during that 4-week period, because it is digging out trauma. When we go to do these settlement process, like to sign a separation agreement, like in the early days, I was literally like doing the whiteboarding and crying for not me, but them crying for like sometimes once in a while on my butt. Not much, but anyway, but like crying like every week, because she's processing just the significant abuse and harm that she's experienced, which allowed her to clear off like 95% of it, right? Because she just was able to release it. That's the level of support that we're able to bring in with highly trained counselors. The other thing just on that, so they need really close legal support and they need therapeutic support. I think and I've seen that if there's a whole way of talking to clients about it as a facilitator that makes them understand how much they hate the way they communicate with each other, right? Like both are dissatisfied with it, I find. And so when I'm able to tap that, and there's a whole sort of thing that goes into it from my perspective, they're both wanting to sign up for having each a communication counselor, because both of them see how they're not served by the current madness between, it's just very challenging. We see a lot, of course. So this is like for the most extreme cases, like we deal with parental estrangement cases, like where one of the or both of the children are separating from one of the parents, like just, and then they don't talk to the family, and it just, there's a whole profile there. That's one of the worst cases, but we deal with those as well. So that's what I would say is the therapeutic component. I'm relieved that finally we have like really combined this so that I really can begin to fully support people through it, because this is traumatic, and that it's not like we're creating more trauma. We're creating structures that they actually, because they have to go through, they have to come through and resolve the legal issues. So they have to confront so much of what was terrible in their relationship. So, but what I'm responsible for is to make sure the structure doesn't harm them, that they're not being hurt by the other party. Like I filter everything, right? Like I'm aware that I'm not allowing one to hurt the other, right? And so there's a whole thing there, but yeah, so that would be what I would say, that the therapeutic piece that of the counselors and being able to integrate them and have the clients understand why they should be invested. It costs money. Of course, they have all these lawyers and these counselors. I mean, you have to be solidly middle class to do it. I would love to, I'm just going to put this plug into it, then I'm going to give it back to you. But I would love to see the legal aid across the country start hiring facilitators and mediators for the low conflict things, because the people that have no money are not getting that type of service, right? People, middle income people can have these services where they're flat feet and you get it done in a certain amount of time and you're not devastated by having to go to family court for 3 days and be cross-examined. It's just brutal, as you all know, I'm sure. So that I would really just put that plug in. Okay, Tod, now on to you.
Okay. Thank you, Lisa. So just to, this process can work where Lisa engages us, the two counselors, to work with both people, and or we may be engaging Lisa as we work with the clients.
Mm-hmm.
And so part of this is about the therapist will be able to addressing stopping abuse and creating safety, addressing issues of trauma and gender that may be hindering the creation of a reasonable and fair separation agreement. And the restorative therapist will we connect with each other throughout the process to monitor issues of safety. I'm just going to slow that down, explain that a little bit more. So in terms of the safety and repair approach to this issue, so there's 3 phases. So the triangles here. So I want to be clear in terms of, and it may be clear, but I just want to make sure. In talking restorative and intimate partner violence, I want to be clear. I'm not talking about necessarily restoring intimate relationships. We're really focused on repairing harm. An intimate relationship may get restored through this process and may not. That's not the top note. The top note is about how to repair harm in relationships. Both, how do you repair harm with the person you hurt, and how do you repair harm with the person who hurts you? So it's about, so there's lots of harm that can be repaired in a relationship. Because I think in the early days, we really kind of pretended around domestic violence that the two parties were just going to go separate and it was going to be over, and then nothing else was going to be, that was the only, that was an option for most people. And of course, the reality is that it's not. There's co-parenting. They live in the same, often the same small community or same social circle. So they're often both still invested in how do you actually repair harm in relationships. The other thing in terms of restorative, what I'm not talking about is a one-size-fits-all approach. It's going to be responsive to individual circumstances. And in particular, it's not about getting together in circles face to face. That may happen in some contexts with some people if it's not going to create more harm. But the principle that we're operating from is, how do you repair harm without creating more harm? So obviously there'd be all kinds of situations where if you get face-to-face contact going, that was going to create more harm. So then we're not going to do that. And at the same time, a lot of harm can be repaired. Maybe it's just through the two counselors who are involved with a particular case. Maybe it's through emails. Maybe it's through telephone calls or video. It's just going to depend on the individuals that we're actually working with. So that's going to be worked out case by case in terms of whether even opening up that communication is a good idea. So it's not even a given that that's necessarily going to be happening in our process, because again, we're just going to hold on to the principle about repairing harm without creating more harm. So we divide the process into a 3-phase process. So you can see these two upside down triangles here are like the two people coming into the process. The first phase is really about setting up safety. And we work in a community context. So the work that I've done has really come out of the women's shelter movement in Nova Scotia. That's where the kind of men's work ended up coming from. And so we're in a rural context. So setting up safety is not just the two counselors, so a counselor for both people. It's also, of course, police, child protection services, separating the parties and talking through this process. So the first phase is about setting up safety. So the two parties are separate, and you can see just how these triangles are set up here. The first phase, they're separated. The second phase is about both stopping the abuse and then preparing them for how do you repair harm in relationships, both with the person you hurt and with the person who hurt you. So people know how to do both. And then moving into the possibility of opening up communication between the two people in phase 3. So through phase 1 and phase 2, you can see how the parties do not have communication. Although the two workers are talking back and forth in terms of issues of safety and so forth, only in phase 3 would communication be opened up between the two parties. And again, we're going to be responsive to individuals around. We're obviously, if we can't move a guy, so if a guy's using the abuse, just use that configuration. If a guy remains in phase 1 and remains dangerous and remains minimizing the seriousness of the abuse, denying the abuse, or blaming other people, and stays irresponsible, we're not going to put him into a conversation with a woman who's in phase 3 and is able to kind of repair harm when she's been hurt. We're not going to set up that conversation. So really from the in terms of our processes around this kind of repairing harm and open up communication between the parties, we're going to move there, if both parties are in phase 3, if people think it's a good idea. As we connect with Lisa's process, there's obviously going to have to be a legal communication that happens, through that process, but again, Lisa and the two practitioners are going to mitigate harm through the process, that we're not going to let either party harm and hurt each other through that process. So I'm just editing for time here. So a big part of that preparation in phase 2 and in phase 1 is attending to issues of trauma. So some people can move through this process quite quickly, like, in terms of the process of moving into communication, because they have a template in place because maybe it was a low level abuse. And we have a whole criteria for moving from phase 1 to phase 2, phase 3 that's worked out. If people are interested, you can follow up on that more. So some people can move through this quite quickly, if there's not a lot of trauma in the conversations. If there is, people have a lot of trauma in their background and are, they're being influenced by unhelpful gender ideas in a severe way, then the process can be much slower. But again, it's going to be dependent on who the particular cases are. So some people can move through phase 1, phase 2, relatively quickly, assuming that all these criteria are met. And some people for which there's a lot of trauma, either one or both parties, may take a lot longer to move into that space. I just want to okay. I just want to move into just a little bit more detail in terms of what this actually means. So this is really, I've got the phase 1, phase 2, phase 3. So this is really broken down into the work we would do is really around these 8 conversations, and then moving into phase 3, which would be practicing the actual repairing the harm and open up communication between the parties. So in that first phase, we're looking at establishing values and identity. So a lot of the work in the initial stage with people as they get referred to us, and this draws on some of the narrative therapy work, really draws on connecting people with their own values and ethics in terms of what is important to them in terms of their relationships, how they want to conduct themselves, and what they want for their children. So I spend a lot of time, if I'm working with a guy who's used violence. Many of the men that we work with are in a mandated context, so it's common for probation service, child protection services. We've been in the community for so long now with this community group that I'm with, Bridges, in rural Nova Scotia. Well, we've been in the community now so long. We do have a lot of volunteer clients too. Men who've referred their brothers or their nephews or whoever into the program. So there's a number of guys who are there voluntarily. And so part of those initial conversations is really grounding the guys in terms of what kind of relationships do they want with their kids, with their partners, what do they want their kids to learn about being in a partnership or in a relationship? How would they prefer to express anger? What do they want their kids to learn about resolving conflict? So again, I find grounding the work in the men's own values and ethics, when that's the configuration, is very important in terms of de-escalating the men, connecting with these values that are actually, I'm setting the foundation for which they would end up confronting their violence on the basis of their own values and ethics, not because I'm cajoling them into it as a social worker. I mean, we do need an oppositional engagement, of course, with domestic violence in terms of policing, child protection at a community level to contain the violence and for the community to take responsibility for safety. And my job within that is really about trying to find ways for the men to take responsibility for themselves and to ground the conversation in their own values and ethics, so that they will, by the time they're done this conversation, they'll end up policing themselves. So part of setting up safety is immediately grounding the work in in people's own values and ethics. Then also attending to physical safety. So that's part of the separating the two clients, addressing social determinants of health, which is also the social determinants of violence and family violence. So also attending to issues of housing, poverty, and so forth, all things that help foster and aggravate violence. But physical safety can also mean somatic work, so some people are coming in, they've got so much trauma going on that they really can't think through and have a conversation with me because they're disassociating in front of me, or they're confusing me with other authority figures, and they're frightened and trying to run for cover and protect themselves. So often that there's that setting up safety in the context of trauma is very important. I recognize that I'm talking quickly. I'm just trying to squeeze like a 90-minute presentation into 15 minutes. So physical safety is important. And then this is also a collaborative process with both people defining what abuse is, defining what repair and taking responsibility is. So I'm not imposing these conversations on the people I'm talking with. I'm really developing their ideas about what they think, how they might define abuse. And there's a whole process and strategy in that process. So I don't get into debates about whether emotional or verbal abuse is abuse or not. So there's all kinds of strategies just to have thoughtful conversations about what abuse is, what the impact is, and what does repair look like, and taking responsibility. As people move through phase 2, and so we all engage everybody individually first. So we're working with people individual. When people move into phase 3, they may also join like a men's group or a women's group, and have conversations in group. They still may be seen at the same time in terms of individually. So they may be both participating in individual process and in a group process. And this just preparing harm is going to be about both stopping the abuse. So there's be developing a relapse prevention plan around the abuse, but it's also going to be looking at not only stopping abuse, but what does it mean to actually repair harm in relationships. So that's what we're heading towards, is like creating the possibility that somebody can repair harm with the person they hurt and or the person who hurt them. And then so where that's going to start is looking at how to repair harm with the person who hurt you. So again, I think in the early days, I spent a lot of time denying that the men were hurt at all. And and I think part of the rationale behind that, not only not heard from their partners, but really the only narrative I had, I was trained in Duluth, for people in the domestic violence field. Duluth was where the power and control wheel came from. And that remains all important work to me. And it was both helpful, but it was also unhelpful in terms of it kind of reduced the issue of domestic violence just to the power and control story of guys use power and control, want power and control, use power and control tactics, and get power and control through perpetrating abuse. That remains an important story. It's just not the only story that's important to actually stop the men's violence. Part of what needs to happen is I need to be able to, in this process, guys would come in. I mean, they would talk about horrible stories of experiences of racism, homophobia, violence from other men, violent childhoods and so forth. And I really didn't know how to attend to that because my story about them was just they had all this power and control by hurting their families. And so really any of the men's own experiences of victimization, I just heard that as them making excuses for their abusive behavior. And I just said, okay, we're not here to talk about that. We're here just to talk about how much power and control you have through hurting your partners and families. And that, especially for guys marginalized by racism and poverty, that really, create a lot of dissonance in the conversations with their actual lived experience. I'm telling them how much power and control they have, and they're like living in poverty and living, in violence. They're often not experiencing themselves as having a lot of power and control. So part of it is being able to really work with guys, both as people who've been hurt other people and have been hurt, thinking about the guys both as powerful in some contexts and powerless in other contexts, that they're both but I'm able to do that working with guys as both people who've hurt people and people who've been hurt, because I get the fact that they're still 100% responsible for their choices. I don't have to deny the fact that they've been hurt, and I think that's what we thought we'd end up doing, just making excuses and erode their responsibility, that we couldn't hold them responsible if we acknowledged any of the victimization. It's just not true. And addressing issues and hearing about the men's own victimization is often, and I wish I had more time to unpack that, is extremely important in moving them towards taking full responsibility for their choices, that they can own more of their responsibility. I thought it was going to go the other way. I thought it would just be a blaming exercises, making excuses and so forth. And there are ways in which, that needs to be interrupted respectfully in the conversation. But I often find guys can hold on to the fact that, they've both been hurt in life and they've hurt other people, and they're not responsible for how they got hurt, but they are 100% responsible for how they've hurt other people, and they can hold on to that complexity. Again, I think it was more me that had the problem with the thinking that they couldn't hold on to the complexity of both, being both oppressor, oppressed, powerful, powerless, and still 100% responsible for their choices at the same time, that there's no excuse for abuse, even if you've been hurt. And that I don't have to deny that fact that they've been hurt to actually focus in on their responsibility at the same time. I know there's lots more I could say around that, but we do work with men to actually address this, because even if they're not being, they think they're being harmed and hurt by their partners, and maybe that's a projection from their past trauma that they've had and it's not actually happening, regardless of whether she's hurting him or not, or other people are hurting, it's not okay for him to hurt back. Like, that's not going to but it doesn't mean I don't want to end up, if she is doing anything wrong, or if he thinks she is, I don't want to end up minimizing that, and trivializing that. I can bring that into the room without turning it into an excuse. In some ways, I want to model compassion for him that I'm going to invite him to actually do with her. As long as I was like challenging these guys, cutting off their victimization and their hurt and their pain, frankly, most of the guys were used to that. That's the only way a guy has ever engaged those conversations. What's more disarming for guys is to be able to have conversations where they can be honest about both the violence they've perpetrated and the violence they've experienced. That went a long way to disrupt, gender expectations in terms of what conversations guys are permitted to have, and went a long way to actually stopping their violence. So I want to look at how both trauma and gender impair people's ability to repair harm. when they've been hurt, but also when they've hurt other people, and how trauma and gender also impair harm in those contexts. As they move through phase 2, they're prepared to be able to repair harm in relationships. Then they move into practicing with the person, and how that communication happens and so forth is going to be dependent on, if it even happens, is going to be dependent on each individual case. I just want to address a little bit more detail in terms of what I mean by repair. So part of this is really drawing on Virginia, Judith Lewis Herman's work. And, it's just really resonant with my own in terms of what do people want when they've been hurt in a relationship. And so just over the years, part of what we've here is about acknowledging the details of the abuse. So they want what happened actually acknowledged. And it's often very powerful for, to move through the minimizing of the seriousness of the abuse, blaming it on others, denying it. So we're going to work on that through phase 2. These 4 components of repair. We're going to prepare people along acknowledging the details of abuse, creating a plan to stop the abuse, acknowledging the effects. This is all going to happen in preparation for phase 3, and then creating a follow-up plan. So there's issues around accountability and stuff for a follow-up plan. Just to slow that down just a little bit more. So in terms of acknowledging the details of the abuse, it's often very powerful for a woman to hear. So if a guy moves into phase 3, for her to hear him say to her that I blamed you for the abuse and that was wrong. I am responsible for what my choices. You didn't deserve abuse. That was wrong that I was blaming you. For her to hear that often from a guy when that's the configuration, is often very powerful in terms of her own repair, her own healing, hearing him acknowledge that, him take responsibility for that. Because we've been trying to convince women for years that they weren't to blame for his abuse. That was part of what we were doing, but when we could actually create a conversation in a context where he would actually own that in front of her and say, you weren't to blame for that. That's on me. Those are very important conversations, and are very important conversations to women who can have access to them. And then, because of course we want to create a plan to stop the abuse, so that's going to all be addressed through phase 2, acknowledging the effects. So we're not going to set up a conversation where a guy is like, we want him to be thinking about the effects, especially before he's thinking about how to repair what he's done. He really needs to put himself in her shoes, put himself in the kid's shoes. There's processes for doing that. And that becomes really important in the process, because of course we're not going to set up conversations with him saying, you don't need to feel that way. It wasn't that bad. It's not that, I didn't mean it, all that kind of stuff. All that stuff, irresponsible stuff, is going to be dried up before we move into phase 3 to open up a conversation that's actually going to repair the harm. And then creating a follow-up plan to stop, to address the effects. So that may be like things, it may be like respecting distance. That may be like, or how we're going to navigate social situations, when, how is that going to get worked out? So there's just, and or repairing holes in walls. There could be all kinds of things that could go into that, how to repair harm. Or it could include, and often does, renouncing the violence in front of the kids. So that, that dad would actually be having conversations. I've had, sons who had experienced, dad's violence over years. And then, the one case I was working with, I'll just finish with this, where I was working with the father. The son's now in his 20s. The son's now violent himself, and dad is thinking through the work that we're doing together that maybe I want to address that. I want to address the violence that I did to him. And in this specific example, I'm thinking about one of the incidents of violence was the son. So he's now in his 20s. And so the dad comes up with the idea, I'd like to have my son come in and renounce the violence in front of you, in front of him. And so part of what happened was, so the son did come in. And so just a background on this is there's one scene in this family, just to give you a sense of the violence, where the son is actually, they're both in the basement, and the son's 14 years old, and he's holding up a bat against his father to try and protect himself from the violence. So then years later, the boy's in his early 20s, and And dad's renouncing the violence and saying that was wrong that I did that to you. You know, there's no excuse for abuse. And the son's response to that was, Dad, no, I was a bad kid. It's okay. And the father's like, no, no. I do not want you walking away from your childhood with that message. The violence wasn't okay. There is no excuse for abuse. It doesn't matter that you were making bad choices or mistakes or whatever, the violence was wrong. So that can become an obvious, both the mother in that kind of situation and the father, they're invested in that kind of repair. And so this process is trying to open up those possibilities. Last thing I would say is when I started this work, we were so cynical. We didn't think the violence was going to stop. We had no vision basically for the violence to stop. We definitely didn't even, repairing the harm wasn't even on the radar. You know, we were just all about safety, which was cool, but we didn't have any vision in terms of what else, you know. So part of this is about answering that question, safety and what else. So that is, and then these, you can see how these two conversations, the legal conversation that Lisa's providing and these conversations with the two therapists on both sides of that, are starting to work together. So I'm aware of the time now and that people wanted to open it up to question and answer.
Thanks, Todd. Thanks, Lisa. That was amazing. We do have several questions, so I'll just go through. The first question, and I guess for you, Lisa, is there ever independent legal representation for the child?
I'll answer that fairly quickly. I haven't had that experience. That's like a guardian ad litem or something where you have legal counsel that only represents or works with the child. So I haven't ever integrated that into that. It's an interesting thought. I do, have like children therapists that are like involved. So recently I brought in Todd's 2 communication counselors. The children actually had a therapist, so I brought all of them, like I did the facilitating so that they all got connected and coordinated so the children would be heard through their children's therapist. Although I think that's a very good question. I'm just going to, for future reference, like there is an interesting issue there sometimes around a legal representative as well. It's more of a technical thing that happens in court, not so much outside of court, but it's kind of an interesting question too. Mm-hmm. Sorry, Kendra, you're on mute.
Oh, sorry.
No problem.
Thanks for that. Next question. Lisa, do you insist on full financial disclosure from your clients before you begin meeting with them in order to deal with the division of assets and debts?
Yeah, thanks. Dominique, that's a great question. Or sorry, Kendra. That's a great question. So the way the program is designed over 4 weeks is I draft a separation agreement and an equalization spreadsheet that deals with all of the assets and the debt division issues. So part of that process is actually having the parties collect that over the weeks. And they know that they need to get it all collected and into me because we're processing that during that 2 hours, putting all the credit cards into the spreadsheet and everything by the time we get to the clients. So that's absolutely yes is the answer. And it's amazing how well this process works to get all of that very tough information. And I'll just give you one quick example. I had a situation where this file was so old, they had been like, it was 9 years ago. I can't remember now exactly, but it was a long time ago. They had separated and they had been fighting since then to get it resolved. And there was a lack of disclosure significantly on, let's say, his part. And I just kept telling him, like, if I don't have that disclosure, this is what I'm going to write into the agreement. And he finally understood that, oh my gosh, I'm going to end up with this really is not where I want this to go, because he had to, it was just going to be completely disadvantaging him. And they just had all kinds of disclosure they would never had before, because he realized that if you don't provide that, I'm going to assume the worst and it's going to go this way. And this is how it's going to go to your 2 lawyers because there's no disclosure. That was the first time he'd ever had that able to be presented to them that way. So I think that it's very important. Yes, it all has to come out. We put it all into spreadsheets and we put it in a Google Doc and send the link to the 2 lawyers. Sometimes I have to get the lawyers, like sometimes they actually help us a little bit, but most times I just get the lawyers, the clients or the customers in this case to deal with their lawyers. But to get it to me, it's all about getting it to me. Otherwise you're wasting your time and you're just missed, that 2-hour slot was to, to track that information into the spreadsheet.
Yeah. Okay, thanks. Lisa, next question from the same participant. How do you decide which category of conflict they fall into?
Again, that's another great
mediation questionnaire of some kind.
Yes, that's a very good question. It is very important. I do have now a checklist of questions that I ask to really get at, there's like 10 of them, but how do you two communicate? How is your conflict between the two of you 1 out of 10? Is there any physical violence? Is there any name calling? What are the finances like between the two of you? I cannot, so that all at some level, and you can also at the intake stage, I'm looking for like fear levels and things like that. That's often indicative. So it's very important to get that. And as I mature in this role as a facilitator in this context, I'm more rigorous than I ever was in terms of making sure initially that they're slotted. If they're slotted in the low conflict, it just doesn't work for a start. And then they complain that they had to actually work with each other. So I just no, okay, I'm going to make sure that you're actually, and if you don't tell me the truth, I can't help that. But I mean, I'm going to really make sure I get the questions asked. So yeah, it's important. And there is it's something I do during the intake with her. Like if she calls me, I do the intake with her. I give him a free 15 minutes to explain the program. I do the same thing with him. Like I understand the level of conflict, and they go to the 5-week automatically. If the test for me is if they can't communicate with one another, they have to be able to work offline. Otherwise you can't do these in 3 weeks, these separation agreements and in my mediation world, and you bump over into the facilitated world because you can't work offline together, right? That is the test. Yeah.
So I guess similarly to that, and perhaps Tod, you might want to jump in here. Are there I mean, I'm assuming that there has to be issues of consent, right? That both parties want to engage in this process. I'm thinking of a lot of survivors who's talked about experiences where their partners engage in legal abuse, right? They use the system as a way to perpetrate further violence and abuse against them. So are there any things that, I guess signs or indicators that you would say, no, we're not going through this? So for instance, someone is involved in the criminal justice system. They may have a charge against them, a domestic violence related charge. Or how do you work with the criminal justice system as part of this? So I'm talking about more kind of like, if you will, more serious cases where there are, say, physical assaults and the criminal justice system has kicked in. Where do these kind of cases fit in here?
Well, again, those are precisely the cases that this program is targeting. So it's very common that we would get people that are under criminal undertakings, like he has to stay away from her because he's assaulted her. Those are those are the ones that we capture in this program. So both parties have to, of course, consent to the program. And my job is to help them understand that you both are in a similar rowboat here. And you are both facing very similar economic dangers. And if anybody thinks that so everybody has to have, not only do they consent, they have to have a lawyer agree with the program, right? Because it's binding at the end of the day. They might want a full trial, but you're not going to get one. So there's all of those safeguards involved. Yeah.
Well, so part of this process, I think, part of why it's structured the way it is in terms of the finances is to try and mitigate the possibility for legal abuse in the process. That's really what it's targeted at, and the financial abuse that can go with that. So it's really trying to attend to that. So it's just not a situation that's allowed to spiral out of control. They contract from the beginning that we don't want to plunge ourselves into massive debt through this process. That does become an important container for containing the abusive behavior.
Yeah. And there's one thing, just for any of you out there that actually are interested in the facilitation work, but if the one party, and I've seen this, like she might actually make more money than him, but he's economically abusive. Let's just say that's the fact situation. I will not do a mediation unless they both have some skin in the game. So he has to have some money on the table, let's say, right? So either we just split it. Usually we just take it out of the matrimonial property, but I typically won't allow it to go forward unless I'm sure that the power balances are okay, right? But one party might agree to pay for everything, but I'm pretty sure the power balances are not, they're set up the right way. But you do have to be kind of aware of those things as well. Mm-hmm.
So
When are you saying that both parties need to be paying for the process? Is that what you're saying?
Yeah, typically
invested in the process. Yeah.
To as a way of creating that investment. I mean,
right. Yes.
if he's the abusive one, and let's just say it's him, but if he's the abusive one and he wants to pay for it all, and I'm assessing that's okay. That's just part of his repair, his sense of guilt, his sense of like trying to make it better. Okay, well, good, we'll go with that.
Okay.
So I'm kind of skipping down on some questions here, trying to kind of
kind
of connect similar questions. So someone else has written in, what do you do in a situation where the male partner's intent is to create harm?
Oh yeah. I guess who is
Well,
that directed?
Okay. I mean, I can respond to that, and then you can respond to it. I
Yeah,
mean, that's what that's often the case, in terms of that's often the starting point. So that's why we're in there, to actually work with that and to slow that whole thing down. And again, so it's not that as I'm talking about grounding a guy in his own values and ethics, part of that process is not about denying that he doesn't intend to harm her, or that the violence isn't intentional or anything. There's all kinds of things going on there. It's about my sense is that if I can ground the conversation and and often it's new conversations for guys to talk loving, caring relationships and nurturing relationships with their kids and so forth. If I can ground the conversation there, it's going to make the abuse seem like it makes, it's not going to make sense. I'm going to be documenting a guy who wants loving, caring, fair relationships. I'm going to be pulling those narratives out of him. And then I'm going to again use that then from which then he can evaluate his own behavior and whether that's living up to his own values and his own, what he wants for his children and what he wants for his partner. So it's not in any way mitigating any sense of intention or bad intention, evil intent. That is what we're going after. So it's not, I'm not presuming from the beginning that the guys are taking responsibility and seeing their abuse is terrible and wanting to, that is the work. Usually the starting point is they're blaming her and they don't see their behavior as abusive at all. That's often where the starting point is. So anyway, that's the work. How about on your end, Lise?
Yeah, I think it's an great question, because as a facilitator, I do run into that where clearly that person is creating that suggestion of a resolution for the treadmill, for example, to harm the other person. So that's where I think it's important that one of the things that really helped me as a facilitator sidestep there's different ways I handle it. Sometimes I've just come right out and say, no, we don't want to say that because that other party might interpret that as being bullying. Right? Like I'm just flagging it right straight. It's not very elegant. I'm just telling him straight out. We're not going to launch it that way. But other times, again, if they're intentionally trying to hurt the parties, and I've seen that, of course, sometimes I actually stop the mediation and week 2, whenever something's going on like that. And I'm telling both of them they immediately need to go talk to their counsel, and they need to talk to the counsel about this particular issue. And then their lawyers are going to support them in terms of how, it either becomes like fluid, like maybe he suddenly stops paying child support, or she wants to move the kid, or outside the province or whatever, or there's just something there. Then I will stop the mediation, or in this case, the facilitation. I'll stop that facilitation and say, no, you're both going to go out right now and chat with your lawyers, and then we're going to come back and deal with the rest of it. But the other thing too is when I hear things like that are, I ask them, how is that going to be taken up by the other side? Oh, they're going to hate it. Well, they're not going to suggest it if it's not going to go anywhere. If they're going to hate it, or they're just going to whatever, and their lawyer's going to reject it. And so that's a very powerful messaging that I learned over the years as a facilitator in these situations is I'm not writing it in the agreement unless I think both of your legal counsel will agree to it. And that was the sweet spot. And once I understood and oriented the parties toward, you actually need to get this agreement by both of your legal counsel. So we're going to exclude everything that doesn't go there. And when people say, no, I still want it in there, fine, we're going to footnote it. And I'm going to say, and so still wants this in there, but everybody understands the law is this, and this is, this is what's going in the main agreement. And then we delete the footnotes later after we get it signed. Or before they get it signed, but that's how I deal with that. I mean, it's a very good point. It was tough in the early days of learning the facilitation skills for these, because they actually actively want to hurt the other, but fair and reasonable, and orienting them toward their lawyers and what judges would say was the way that I was able to completely blunt that. And I sidestep it very well now, I would say. Yeah.
Okay, thanks, Lisa. So I guess following that kind of line of thought, so what if one partner refuses to participate? Like, is there any recourse, or does it just kind of kick into kind of the more traditional family law system?
No, it's great. Well, this is what I really, I'll just speak first, if that's all right, on the legal program. This is what I find actually is important about this 5-week session program, the 5-week program, is that at the beginning, they contract with me, and they have lawyers that have signed off on this, and it's, it could be binding or non-binding, but I often just get them to sign up for the binding because they're going to minimize that financial harm. But so because they have signed off on oh, sorry, I just lost my train of thought there. What was your question? Sorry.
If the one party doesn't want to or wants to bolt.
Yeah, so that sometimes happens, that in week 3, that party, and it's actually often the more abusive party, doesn't like where this is going. They lost control of the process, and that's the point. If they haven't had Tod's the benefit of Tod's therapeutic process, and I haven't been able to really inject too much of it, they don't like where this is going. They will say, okay, no, I'm not participating in the program anymore. The answer to that is, okay, that's fine. You don't have to participate, but there's a contract that binds all 3 of us, including me as the facilitator, and I've contracted with your partner to continue to have these sessions. So you can choose not to participate, but the contract is still binding on all of us. You just won't participate, and I will continue to draft all of these documents based on what I think is fair and reasonable, with input from the spouse that is going to participate in it. So that's how I deal with that, and it's binding. At the end of the day, they can say they didn't participate. That's right, they didn't participate, but that was their choice. They were all under contract to continue to do it until they went to the family judge.
Okay, thanks, Lisa. Other questions are about the cost of the program. Is it prohibitive where, I guess, those living in poverty can even participate in these types of programs?
Yes, I would say definitely the high conflict 5-week program is prohibitive for low income people. The lowest income people have to go to legal aid, and they only get the very adversarial harming, like, the harms that come from an adversarial process, and it's very adversarial. So no, that is cost prohibitive there. For the lower conflict type of mediations for separating couples, those tend to be like, have a broader range of affordability, because a lot of times they might borrow it from family members or something, because it's so quick, short, and done. They can talk relatives into, like, okay, like, I'll spend it, but what's the alternative? Every lawyer requires $2,500 retainer in their trust account. So there is a price point there that they, and again, I really would like to put the flag out there for legal aid across the country. I think it would be wonderful to introduce these type of facilitation services for high conflicts and mediation for the low conflicts.
Thanks, Lisa. Another great question. So what happens when one party, goes through this, then refuses to accept responsibility? I think you mentioned it goes to binding arbitration, right?
Yes, goes with the judge. Yeah, binding judge.
Yeah. So does the judge get this information? Like, does the judge get your notes and anything like that?
No, the judge doesn't get the notes, my notes, and in the contract, I'm not a person who can be subpoenaed, so they contractually agree that I'm not going to be subpoenaed. I do offer like a 3-page sort of memo, and the purpose of that memo is to briefly summarize, these are the issues. like I'm filtering this through a legal framework. So these are the legal issues. These are the relevant facts I know you're going to appreciate. And and she's saying this, and these might be the two facts that they both disagree on. If there's too much credibility, the judge can order it to a trial, but they're the only ones that can order that. Otherwise it's going to be contractually going to the binding settlement judge.
So would the judge know that they were to participate in this program and then they refused, or?
Well, if it goes, see that once the application documents are sent to the court in week 1, it shows up in the court place and like in the courthouse, right? So it's part of their filing system. So they will contact both parties and say, you're going to need to show up at the settlement conference, judge. If you don't, the judge will order things without you being there. So you don't have an option not to participate once you start. And this is like my other brother, Sean, as a lawyer. And so he and I work together on how do we handle this group? Like, how do we get, and so they can't back out because they've done an application at the beginning, and you can't say you're not going to show up at court. You can, but you're going to get something ordered against you if you don't show up for court, right? And so that court includes settlement conferences with judges.
Okay, thanks, Lisa.
Yeah.
How do people access these services? Can they access it on their own, or are they typically referred by agencies that they become involved in, or both?
So Tod, I'll just answer and then jump over to you. So for our programs, I do that. It comes through the front door. So I do most of the intakes for our firm, and particularly for the family, because of these programs. So people come, they're called for a family lawyer, and then I explain the different tools that we have available and the price points. And so the most popular are these mediation programs because of the flat fee involved, and the timeline is very quick. We also offer legal coaching, which is they represent themselves, like not for high violence situations, but because that doesn't work, but for lower conflict ones. And so that is another affordable option. There's no retainer. You just like pay as you go. It's like a haircut type of thing. Tod? How do people come into your system?
Well, yeah, I mean, people can self-refer or be referred, by other agencies.
Okay, thanks. I'm just looking at the time. I'm going to lump two questions together, but it looks like there's a fair number of people that have, and maybe they're from family lawyers, that have specific technical questions related to the program.
Yeah.
Lisa and Tod, do we have maybe access to your emails that we can maybe forward people on to ask those questions to you?
Sure, that's fine, no problem.
Sure.
So the other questions I think are useful would be, how does someone receive training or mentorship in this type of practice? Do you have that as a component? And then secondly, has this been evaluated? Like, are you able to kind of see the impact that this has been making?
I think, Tod, maybe, I don't know maybe you should answer this, Tod, and then I can jump in.
Yeah, would make sense. So, I mean, people can look through, there's a website, and, I offer trainings, both I'm often invited into organizations or into different communities. But I also, if you look on the website, have, trainings that I offer for people to get involved with. The next ones will be in the fall. And Lisa and I haven't worked up specifically. We're happy to be doing these kind of presentations, but Lisa and I will, in future, be working up trainings that will have both of us involved in it, for both lawyers and for social workers and other community workers that are doing this work. But we're also available for consultation and on specific cases. Just. And we can be reached through the emails.
I guess for my program, the facilitation program, this one in particular, it's very challenging to, it's a mentorship process, actually, because one actually has to experience, it's like litigation. When one learns litigation, you actually have to mentor with a litigator. You can't get it like from, you have to actually have that person there. So the best people so it's our article clerks that sit in on these facilitations and the mediations. Those clerks learn from the ground up what this style is. And I think it's very hard to change hats once you learn the traditional role model. It was only because I was completely immersed in restorative justice at the commission that I got out of that model and could look and critique it and then create something different. And so, like, you know, I know people that would lawyers who would do this method, but it requires, it's just very hard to make that transition. So it's not that, and like Tod said, it's not like it's definitely can be trained. And my brother, the other brother who's a lawyer, he completely started to do this, and he developed his own very interesting program for flat fees if if you're self-representing, let's say. And so he sat in on a lot of these mediations, and it was very much you get it by osmosis. So if people were interested, that would be the way to do it. You would have to sit in on as a training like you'd have to be like, and that's fine. We always need a second pair of hands, but right now it's the clerks that are the second pair of hands.
Well, and a lot of your work is done via Zoom.
Yes, it is. All of it except the last.
That's right.
The last
That's right.
appointment or whatever.
So that could be part of the training for sure.
Yeah, that's right. Training. Yeah.
And in terms of it being evidence-based, have you done any type of evaluation or?
There's, in terms of the, narrative work, there's lots of, or two things I would say around that. One, when we were kind of trained in that, an oppositional engagement with the guys in the early days, and we made a shift over to this kind of restorative narrative sensibility. There was just no comparison in terms of the responses back from the female partners in terms of what was actually going on. We could just see how much we were actually escalating the men before through our kind of oppositional confrontational practices, which, I don't say with any sense of happiness. But just as we moved that process. So, but there's also been, so there's been lots of research around cognitive behavioral work and narrative in terms of effectiveness. In terms of the specific approach, there was a study done in Yellowknife on the approach that, I trained there, and I can share that with people. Currently in Atlantic, Canada, we've got, I think it's $600,000 grant with Dalhousie University, and we have sites across Atlantic Canada running the safety and repair approach online. And so that research, it's a 4-year project. We're into the 2nd year of it. So, that's part of the evaluation process is forthcoming with that project.
Great. Thank you. Sorry, Lisa, did you want to?
I was just going to say the only evaluation so far is how many, how well the program works. So I get feedback from independent legal advice, and I also just keep stats. So it's that's how that works. So, the low conflict mediations, 95% of them settle, and the high conflicts ones, and I tell people this, the high conflict ones with domestic violence or otherwise, just the high conflict ones have a 50-50 chance of settling if you don't have a binding settlement judge.
Great. Thanks, Lisa and Tod. And thank you everyone for your questions. A lot of great feedback, people thanking you, and Tod, thanking you for your, just reminding us of looking at a more fulsome story, especially of perpetrators' behaviors, right? Where we tend to just focus on the power and control, right? But understanding that there's trauma that, for those who use abuse, that is underlying some of that behavior. So Masha, maybe I'll pass it on to you, and Patricia, if you can load the PowerPoint presentation back up, and we will just move forward for the rest of the presentation.
Thank you everyone for attending. We would like to ask you to complete a survey. It's an evaluation for this webinar. So it would be great to hear your feedback on the webinar next. So the link is in the chat. And again, I just wanted to let you know that this is a project that is led by the Alliance of Canadian Research Centers in Gender-Based Violence with Western University as the lead. And you can visit our website, which is, I hope it's in the chat as well, in order to access the past webinar as well as the recording of this webinar in the future. You can also see the briefs that we produced and the PowerPoint slides of the webinars as well. Next. And for those of you who would like to have a certificate, we have a certificate that we provide. It's for registered social workers in Manitoba. They can claim 1.5 hours towards continuing competence program. you can visit the website that is also available in the chat for details of this opportunity. Next. And you can also check our social media, our Facebook page, Instagram page, as well as Twitter, and our website, which is umanitoba.ca resolve. And you can also reach us via our email, which is resolve@umanitoba.ca. Next.
Again, I just want to thank everyone for attending. Masha, thank you for organizing. And of course, Lisa and Todd, thank you so much for the great presentation. Just excellent, and you know how practical it was, especially for those who are practicing in family law. I think it's really, really useful information. As a reminder, the webinar was recorded. We will make it available on the Resolve website as well as the Alliance website. And Lisa and Todd, we have your emails available. I guess we'll get that to people somehow. Hopefully we'll be having another webinar related to family law issues and family violence in the fall. And of course, we're always taking you know, people's feedback. So if you have ideas of upcoming webinars, what you would find useful, please let us know. Anyways, with that, I will say goodbye to everyone. And again, I want to thank everyone for attending.
Thank you
Thank
very much for
you.
inviting us.
For sure.
Here.
Thank you.
Okay, bye.
Bye-bye.
Thanks.